Welcome and good morning to all in UK and good afternoon to all in India. Moore Kingston Smith is back with its ongoing series of webinar on COVID updates on doing business in UK with our commercial partners with latest updates and adding new dimensions of knowledge towards improving your new or existing businesses in UK. I welcome all of you who have joined in today's webinar with the latest updates on coronavirus for the Indian businesses to operate or keen to operate in the UK. Hi, I am Bharat Rampal, Vice President Business Development at Moore Kingston Smith, working as a key member of the Indian group based here in Gurgaon, North India. A special thanks to all our business partners and today's panelists from London and Partners and Howard Kennedy, who will enlighten the audience with the latest updates and how we all can jointly support towards safeguarding your business and employees in COVID times. While the entire world continues to go through turbulence, both Indian and British economies are trying hard to sustain. Hence, reopening of investment and trade should bring both the economies back on their respective feet. This June, as India enters phase of lockdown 5.0, the center led by Prime Minister Modi has eased restrictions across the country with Unlock 1.0. The state governments have come up with their revised guidelines to contain the spread of the COVID-19, which has been supported by all trade and business associations. And similarly, British Prime Minister Boris Johnson has initiated unlocking of UK in a phased manner and have extended support to all existing businesses on the land of UK, which our team has conceptualized in form of latest offering, which is also our agenda of today. In our agenda, we will be covering UK-India relationships and support available to companies, latest updates on business reliefs, including the furlough scheme, which will cover topics like job retention scheme, covering latest furlough grants, payment due, and many more tips. Other key agenda will be employees to return to work with updates on HNS obligations, topic on ensuring health and safety in workplace with concerns from employees, redundancies along with TNCs. We would also like to cover another most crucial aspect under navigating coronavirus in UK, financing options from the UK government, which will enlighten you with topics like loans from banks for SMEs, bounce back loans, topics like C bills and CL bills, support for startups, and many more, followed by a Q&A session. Please also allow me to share some housekeeping rules for today's webinar. This webinar session will be recorded. You will be able to see and hear panelists. For audience, we have kept mic on mute. Also, you can see we have Q&A chat icon at the bottom of the screen. So please use it to comment, suggest, or ask any query throughout the session. Once all presentations are done, we will all have Q&A session in end, and we will try to address as many as questions we can keeping time in mind. And in case due to any time constraints, we are not able to address your queries or you have any further thoughts, you will send me a specific query even offline. Before you hear all these interesting topics ahead in detail, please allow me to introduce our commercial partners and panelists of the day, starting with our guest, Julie Chappell from London and Partners. Julie Chappell is Managing Director of International Markets at London and Partners, the Mayor of London's International Promotional Agency. Julie oversees London and Partners activities in China, India, North America, France, and Germany. Prior to this, she was Chief Digital Officer for the company. Moving ahead to our legal partners, Chirag Rao from Howard Kennedy. Chirag Rao is a real estate lawyer and heads up Howard Kennedy's India Group. As India Group head, he works with the group on strengthening ties with India and advising Indian businesses on inward investment into the UK, as well as acting for Indian diaspora clients within the UK. As a real estate lawyer, Chirag supports clients on the full suite of development matters, including investment, development, including development finance, corporate support, acquisitions, and disposals. From Howard Kennedy, we also have Anjali Rawal. Anjali is an employment solicitor advising on all aspects of employment law issues, from providing day-to-day HR support to acting in relation to contentious litigations matter and complex corporate transactions. Anjali works with a range of domestic and international clients, including clients based in India and Indian diaspora clients in the UK, and her clients range from senior executives to multinational corporations. On behalf of Moore Kingston Smith, I'm also pleased to introduce Tim Stovall. Tim is a head of tax at Moore Kingston Smith. and specializes in a wide range of tax planning, including domestic and international corporation tax issues and employment tax. He also has an extensive experience providing guidance and insight for Indian clients who wish to invest or start a business in the UK and part of Moore Kingston Smith India Group. Tim is based in our city office. And last but not the least, from our Heathrow office, we have our partner Vijay Tanna. Vijay is a general practice partner at Moore Kingston Smith and also part of the India Group. Vijay has been helping entrepreneurs and not-for-profit organizations succeed in business for 30 years. He advises clients on their audit and assurance, accounting and tax compliance, as well as their strategic business and tax planning. Further, without taking any more time, I would like to invite our first guest speaker of the day, Julie Chappell. Julie, over to you.
Hello, I'm Julie Chappell, and thank you for inviting me to participate today. And it's great to see that the session is so well attended. So to set the scene, the ties and cooperation between India and London remain strong. 842 Indian companies have set up in the UK with 41.2 billion total turnover in the last financial year. And 54% of Indian companies choose London as the location for their HQs. Technology and telecoms companies continue to dominate the list of fastest growing Indian companies in the UK. And leading Indian technology companies such as Infosys, TCS, Tech Mahindra, Wipro, and HCL employ over 30,000 people in the UK. And the Tata Group companies dominate the list of major UK employers, employing over 70,000 people in the UK. And London remains the top place in Europe for creating high growth tech businesses, with research revealing that London has created 46 unicorn companies. But having said all that, we know that right now many businesses are facing huge financial and logistical challenges, but we are seeing new rising stars in emerging sectors such as education technology, remote medicine, and e-commerce. Can we go to the next slide, please? So how can London help your business? Our teams in India and our sector experts in London support Indian businesses who would like to scale internationally with advice and connections and reasons to choose London. But when a business is operating in London, we offer smaller companies via our business growth program, mentoring, networking, events, and access. Now, Mayor's International Business Program is for larger established companies who wish to expand further internationally. And we now have a full calendar of virtual international trade missions, the first one being an EdTech one to New York, which happened just over a week ago. So we are pivoting, we're doing things differently, we're responding to what businesses really need. We also have a business resilience series of webinars that help businesses to navigate the crisis. The Business Growth Hub is online support for businesses, giving advice and providing virtual workshops and events. Pay It Forward is a mayoral initiative which allows consumers to support businesses by pre-buying goods and services. And at London and Partners, we're about to launch a new London Recovery Alliance, which will allow businesses to participate in large-scale marketing initiatives to build consumer confidence and kickstart participation when the conditions are right. And obviously engaging with real subject matter experts, such as the ones you will hear from in this session, is invaluable for any business. So over to the second speaker.
Okay, thank you. So as Barrett kindly introduced me, I'm Tim Stobald. I head up the tax department of Moore Kingston Smith, and have always had a great interest in India and look after quite a number of the companies that Julie's just mentioned. Sean, if we just move on to the next slide. So my focus for the next 10-15 minutes or so will be to talk through the changes to the furlough scheme. We timed this webinar, especially to allow the Chancellor to give his announcement, which was promised by the end of May on the changes. He left it right until the last minute, made the announcement at 5 o'clock on Friday of last week. So we've been digesting the announcement and all the releases that came with it. So I'll run through that and how things are going to change. I would expect that most of the attendees on this webinar already have some familiarity with the furlough scheme. It's been in existence since middle of March, so around for a few months now. And a number of the attendees, those I've seen on the list, I know are already claiming the grant. So what I won't do is go through all the detail of the scheme, which most of you will be familiar with. If there's anybody on the scheme who hasn't, or on the webinar who hasn't heard of the furlough scheme, just drop Barra an email afterwards and we'll send you the slides from the previous webinar that are a good run through. So as you can see, I suppose the number I'll just point to on that first slide is there are 8.4 million employees under the furlough scheme at the moment, which given the population of the UK is a big proportion of our workforce. And the scheme now we know will come to an end later this year. It is, and there's a number to focus on at the bottom because it sets the context for some of what I'm going to talk about, a very expensive scheme for the UK government. It is costing, or has cost so far, 15 billion. And with the months it's got left to run, I wouldn't be at all surprised if that number's going to be, you know, another 10 billion higher by the time we get to the end. So next slide, please, Sean. So I said I won't do too many reminders, just a quick reminder of what the scheme was when it was launched. What it does is it allows employers to claim a grant from government for the lower of 80% of the normal salary of the employee, or £2,500 if lower. Any amount that employers claim must be paid to the employees. They can't take it as just enhancing their own profits or reducing their losses. Along with the grant, the associated employer's national insurance under the scheme as it stands is paid also. If you're employing individuals seconded from India to the UK, you'll be aware that national insurance is not paid for the first 52 weeks. So the employer's national insurance only forms part of the grant if it is being paid. And then to the extent that any pension contributions are being made under the auto enrolment scheme, the grant as it stands currently includes that minimum contribution as well. But again, a lot of secondees won't be paying that. So that's what a lot of us will know and love already. So how's this changing? Sean, next slide, please. Right, so what I tried to do was reduce everything just down to a table. So up until the end of July, nothing changes. So we were told in the last round of announcements and modifications of the scheme that it would run to 30th of June. That's now been tipped forward 1 month, so now runs to the end of July in its current form. Nothing in the rule book changes whatsoever. So it's still £2,500 or 80% of earnings, whatever's lower. Should say minimum rather than maximum there. First error in the slides. It's their first outing today. And the employer doesn't have to contribute anything towards the furlough grant, and the tax man still picks up the employer's national insurance and the pension fund. Now, August is where the first change comes, and may not be such an enormous impact to Indian companies operating in the UK. So the furlough grant remains the same. We've got the same £2,500, 80% payment of the furlough grant, but the government will no longer pick up the employer's national insurance or the auto enrolment minimum pension contribution. Now, for secondees from India into the UK who are within their 52-week exemption for national insurance and who would not ordinarily be in the pension scheme, that shift will not make a huge difference. But for any local hires you've got, or any Indian secondees who are in the UK for longer than 52 weeks, or that you have put into the pension, that's going to add to your cost in August. In September, this is the first point at which the employer is having to contribute towards the furlough grant. So in order to claim the £2,187.50 from government, the employer will need to top up £312.50 to get to the £2,500. So that's the first level of contribution. Again, the national insurance and the pension, that liability remains with the employer. And then October, which is the last month of the scheme, the employer contribution goes up. So at that point, the employer is contributing a quarter of the cost of the furlough grant, £625, and is claiming only £1,875 from government. Now, the Chancellor has been pushed on the 31st of October date, and the questions which have been put to him in Parliament and in various question times is what happens at the end of October if the economy is not back on its feet. Would he extend the furlough scheme any further? And his answer, he doesn't pause for breath, he says, no, that is the end. Of course, it may not be. If the economy is still struggling at that point, it may be extended. But as we know at the moment, 31st of October will be the end of the furlough scheme. So as we'll hear from Anjali later, that will sharpen up UK businesses to think about when their redundancy programs may need to start if they don't think they can engage with all of their employees. Next slide, please, Sean. I thought the accountant in me wanted to put all that in a table. I won't talk through every single number, but that's showing effectively the cost to the company. So at the moment, if the employer's national insurance and pension is being paid, you'll see up to 31st of July, the total grant claimed per month per employee could be as high as £2,803. If we go all the way through to October, where the maximum contribution is being made by the employer in the last month of the scheme, you'll see that the cost to the employer is about a third of the overall grant. So even though the employer is only contributing about a quarter of the actual grant itself, the employer's national insurance and the pension mean that the employer is meeting about a third of the employment costs. And if the business, the employer, cannot meet those costs, if there's not sufficient income coming in, again, that's going to bring the mind towards the horrible word of redundancies rather than actually incurring that cost. So that table's just there to show how the furlough grant changes over the next few months. A few bits of the detail. So most of the focus around the announcements in the press are focused on the fact that the level of employer contribution and the way the national insurance goes. There's a little bit in the detail that's worth knowing, a bit operational, but I think it's important to say. At the moment, any furlough claims can be made for any period. So if you wanted to claim from the 13th of May to the 4th of June, you could do. No reason why you'd want to, but you can claim and straddle months. Because the rules start to change every month from the 1st of July onwards, claims can only be made for whole months, and that may affect your cash flow. So if you have to actually wait for the payroll to be paid before you make your claim, you may find the cash is going to come in a little later than you would otherwise expect. I suspect we can structure the timing of the claims to avoid that problem, but be aware it's only whole month or part of a month, as long as it falls within the month, claims that can be made. The other point I think is probably more significant, which is that the number of employees an employer can claim in any claim period after the 1st of July can't exceed the maximum number they've claimed in any previous claim. So this is the Chancellor saying he wants furlough claims to get smaller or cover fewer employees rather than get bigger. Now, that would mean, I think, any previous claim when we hit the 1st of July will be any previous claim from March all the way up to the end of June. But that's your maximum number of employees. So if your business suffers, a greater stress and pressure, and you need to furlough more employees, this is one of a number of tweaks to the rule that's going to restrict you doing that. So you cannot claim for more employees after the 1st of July than you've claimed for before. Next slide, please, Sean. Also, in order to try and limit the cost to the Treasury of the furlough scheme, the scheme's been closed for new entrants from the 1st of July. So midnight on the 30th of June, that's it. If you've been furloughed already at some point in the period up to the 30th of June, you're all right, you're in the club, you've got your entry ticket to being furloughed after the 1st of July. If your employees haven't previously been furloughed, so you've struggled on until now, but you think you may need to make use of the furlough scheme from the 1st of July onwards, you will need to furlough your employees no later than the 10th of June. And why the 10th of June is an important cut-off date is that before the 30th of June, the employee must have completed a furlough period. So the minimum furlough period at this point, under this version of the rules, is 3 weeks. And therefore, to accrue 3 weeks of time on furlough, the latest an employee can be put on furlough is the 10th of June, so they've got time to have their 21 days of furloughing. If you furlough anybody after the 10th of June, there's nothing to stop you. Well, actually, anybody furloughed after the 10th of June, I think those furlough claims will probably be rejected because you won't you won't have the 3-week period, and after the 1st of July, the scheme will be closed to those employees. There's a slightly relaxed period to make the claims for your employees who are furloughed up to the 30th of June. So there's until the end of July to make those claims. Next slide, please, Sean. So my second and last reminder, so one of the biggest criticisms of the furlough scheme was that those employees who were on furlough couldn't carry out any work for their employer whatsoever. So if you had some work for your employee but not full-time work, you couldn't furlough your employee for only some of the time. It was an all or nothing. So the employees could provide no services whatsoever to their employer and generate no income for their employer directly or indirectly. This is one of the areas we're expecting HM Revenue and Customs to come in and check the most going forward, because it's the area where I think employers are going to slip up the most. Under the rules up to the 30th of June, as I've mentioned, the minimum period for furloughing is 3 consecutive weeks. So what changes from the 1st of July? Sian, next slide, please. So from the 1st of July, we have this new word, flexible furloughing. So flexible furloughing is allowing employees to come back into the workplace and work for their employer, and still, if they're not coming back full time, be furloughed for the time that they're not working. Remember, this will only be for employees where the scheme is not closed to them, so it will be for employees who were previously furloughed, which is why that 10th of June date is so important if you want to flexibly furlough somebody from the 1st of July onwards. So employers can claim the grant for the time that the employees don't work. I've got an example for that in a slide or two's time just to show how that works. And the minimum furlough period now drops from 3 weeks to 1 week. So you've got a bit more flexibility on bringing people back into the workplace. You could bring somebody back into the workplace to work 3 days in a week and still claim the furlough for the 2 weeks the 2 days where they're not working. Next slide, please. So Anjali, maybe covering this, as with any furloughing arrangements, you need to agree terms and conditions with the employees in writing. So if you are bringing employees back under a flexible furlough, you do need to make sure that's set down in writing with them. We're waiting for more guidance on flexible furloughing and quite how the arithmetic is going to work, which should be due on the 12th of June. If you just go to the next slide, Sian, I'll just give an example of how, at the moment, we think this is going to work. So I've taken a salary, sort of finger in the air as what might be paid to somebody on a typical Tier 2 ICT visa. So I've chosen 42,000 just to make the arithmetic nice and easy, £3,500 per month. If that employee comes back having previously been furloughed, so they've got an entry ticket to the flexible furlough scheme. So if they come back to work for 3 days per week, and let's say that the employer decides to pay them their full salary for the entire week rather than reducing the salary for the 2 days that they don't work, just to keep the example simple. So in August, the employer pays a gross salary of £3,500. If there's national insurance and pension being paid, the employer meets the cost of those too, because that's now the employer's problem and no longer covered by the government. And then the employer claims under the furlough scheme 2/5 of the normal grant for the 2 days that are not worked. So 2/5 of the lower of 80% of the reference salary taken from February 2020, same as the old rules, or £2,500. So in this case, it's 2/5 of £2,500. So the furlough grant is £1,000. So this is the Chancellor's plan of how he's going to get people back into work by relaxing the furlough rules of not permitting the employees to carry out any work whatsoever, and to give employers some benefit of a grant. Next slide, please, Sian. Right, just very quickly in the last minute I've got in my allocation. This is the revenue showing their teeth for the first time in terms of enforcement around the furlough claims. So if what happens after the event is the revenue discover that the furlough grant claim was wrong, either the employees were carrying out services for their employer but doing it in secret, or doing it by accident, or errors were made in the claim, or the grants that were claimed were not paid to the employees, or just straight out fraud, the revenue have the ability to raise an assessment on the company, the employer, in the first instance, to claw all of that back. Next slide, please, Sian. So, however, I think the revenue have been around the block a few times and have realised that if they start sending tax assessments to companies that are already struggling, there's a reasonably good chance those companies will disappear out of existence and the revenue won't get paid. So what they have is some enhanced power. So if the company is in serious, there's a serious possibility it might enter liquidation or administration, or it's already in liquidation or administration, and the directors knew at the time that the revenue tried to recover the furlough grant that it should have been repaid. They've discovered it was claimed in error, or if they knew there was fraud, and the company's going to be unable to pay the revenue themselves, then the directors, the individuals, become joint and severally liable with the company for the grant being clawed back. So this is personal liability of directors for incorrectly claimed furlough grants. Now, this is only where the directors know that it's incorrect. If it's just innocent error and the revenue discover that later, there's little chance of the directors being personally liable. But if the directors know that the claim is incorrect or fraudulent, they do risk personal liability for the grant being claimed back, which could be significant. Sian, next slide, please. There's also fairly draconian penalties. So there's a deeming of this offence to be of one of the worst categories, of deliberate and concealed offence. So if the revenue can claw back the furlough grant, they're effectively able to double it, because the penalty is up to 100% of the grant claimed in error or fraudulently. So you can see this is quite a tough regime to focus the mind about making sure these claims are correct. So wrapping up, I think the extension of the furlough scheme is generally good news up to the end of October. The flexible furloughing, generally good news. Watch out for the scheme being closed to new entrants from the 1st of July, and be aware, or at least make sure the directors of your business are aware, that if this is all completely wrong and you knew it was wrong, the directors themselves may carry some personal liability. I think that's the end of my session, Sian. Thank you very much.
Thank you so much, Tim. That was very insightful and informative. I will be speaking very quickly, just as an introduction before I pass on to my colleague Anjali. My name is Chirag Rao. I'm the head of the India group at Howard Kennedy. Howard Kennedy is a full-service, London-based law firm with a global reach and specializes in really providing straightforward advice to entrepreneurial businesses and individuals on domestic and international matters. We are a firm with an extensive history of supporting international companies to set up and operate in the UK by ensuring that the journey to market is as smooth and as seamless as possible. And that is why really our commercial partnership with L&P is an important thread to our firm's international strategy, and why we're so thrilled to be part of this webinar today with another of L&P's valued partners, Moore Kingston Smith. Our India group advises Indian clients from India and within the diaspora across a range of sectors on commercial, corporate and real estate transactions. We combine an understanding of the Indian market and clientele with a highly personalized and straightforward approach to deliver solutions and practical advice for our ambitious clients. We also advise non-resident Indians and high net worth individuals on their private client matters and deal with all forms of commercial dispute resolution. As Julie said, there are nearly 842 companies operating in the UK, Indian companies, with revenues of over £41 billion. And that just shows that despite a highly unsettled environment, Indian companies have continued to make a significant contribution to the economy. And there is evidence of an enduring long-term partnership between the two countries. I'm really pleased that we're part of this webinar, and my colleague Anjali Raval, who is an employment expert, will now be talking about the legal aspect of what Tim has been talking about. Thank you so much.
Thanks very much, Chirag. He's obviously done the introduction. So yes, I'm an associate in the employment team at Howard Kennedy. And today I'm going to try to address some of the employment law issues that businesses should consider when navigating coronavirus in the UK. And this is a huge topic that we talk about for hours. But I'm going to briefly run through some of the key points for consideration, in particular, ensuring health and safety in the workplace, planning for your employees to return to work, and then the difficult topic of redundancies and changing terms and conditions of employment. Tim's already dealt with, the current state of play in some detail in terms of the furlough scheme. Essentially, as he said, the government scheme has been extended to 31st of October 2020. And from 1st of July, which is earlier than we had originally anticipated, it will be possible for employers to bring back furloughed staff to work part-time. The government's message still seems to be, If you can work from home, do, but if you can't, then you're encouraged to return to work. Planning for return to work is potentially a minefield for employers. However, considerable guidance has been issued, which should hopefully assist. For example, the government has issued sector-specific guidance on working safely during coronavirus. The key obligations for employers is that they should do all that they reasonably can to set up a safe system of work and ensure that it's implemented. So compliance with government guidance will be good evidence of what's reasonably practicable and is highly likely to set the standard in terms of what the health and safety executive require and in terms of what enforcement action it might take. So some of the key themes that run through the guidance are as follows. All employers need to carry out a health and safety risk assessment before allowing staff to return to work, and this should be shared with staff. Employers should consider publishing the results of their risk assessments on their websites if possible, and actually businesses with 50 or more employees actually are expected to do so. Employers also need to consult with their employees and or elected representatives about the health and safety measures proposed to be put in place. It's all about basically making your workforce comfortable that they're returning to a safe workplace. The guidance states that the objective is to reduce risk to the lowest reasonably practicable level by taking preventative measures. Businesses should make every reasonable effort to enable staff to work from home in the first instance, if that's possible. Where it's not possible, workplaces should make reasonable efforts to comply with the social distancing guidelines set out by the government, basically that everyone should be 2 meters apart wherever possible. Where the social distancing guidelines can't be followed in full, employers should manage the transmission risk. In relation to a particular activity, for example, businesses should look at whether that activity is actually needed for the business to continue to operate. And if it is, then the business should be taking all mitigating actions possible to try to reduce the risk of transmission between staff. Some practical examples could be, including erecting physical barriers in shared spaces, or creating workplace shift patterns or fixed teams to minimize the number of people that are in contact with each other, or ensuring that colleagues are sort of facing away from each other and spend the minimum amount of time together in close proximity. Of course, workplaces need to be kept clean and cleaner than they usually would, and there needs to be more attention to detail in this regard. One of the questions that we've been asked that seems to come up is whether employers need to provide their staff with PPE. Essentially, the guidance states that employers are only required to provide PPE if they would normally be required to provide it for sort of non-COVID-19, to protect against non-COVID-19 risks, or where you're in a clinical setting. So generally speaking, the answer will be no, you don't need to provide PPE. So let's assume you've carried out all the health and safety risk assessment and you now want to take steps to get employees back to work. You'll need to have at the forefront of your mind that individual employees will be facing very different challenges and will have very different risk profiles. So you've got individual risk profiles, you've got caring responsibilities, you've got home environment or commute that may make different individuals feel differently about a return to work. And from an employee relations perspective, understanding what each individual's views are and seeking potentially possible volunteers to sort of return to work may be a sensible first step before bringing back the entire workforce. The guidance makes it clear that shielding employees, i.e. the group that has been identified as extremely vulnerable, must stay at home. That applies even where they want to return to work, and that has been a question that we've been asked. My employee wants to return to work. Unfortunately, here the answer is no. There are options, so an employee in that category could be furloughed under the scheme for so long as the scheme continues. Alternatively, the statutory sick pay regulations were amended with effect from 15 April 2020 to also enable shielding employees to be placed on statutory sick leave, where basically making them eligible for statutory sick pay where employers can't furlough them for whatever reason or don't have any other policies or procedures in place to protect them. The remaining vulnerable group, including those aged 70 or above, have been asked to take extra care in observing social distancing and should be helped to work from home again where possible, either in their current role or potentially in an alternative role if there's one that could be done from home. If they do have to attend site, they should again be offered the option of the safest available role possible on site. Again, that may involve having discussions with them about changing their terms and about changing their duties, whether that's for a prescribed period or for a longer term period. Those employees won't qualify for statutory sick pay. So where it's not possible to reduce the risk to a level that is manageable or to an acceptable level, employers should be considering alternative options, and that may be suspending those employees on full pay until the risks have been reduced sufficiently, allowing them to take annual or unpaid leave, or potentially keeping them on the furlough scheme until it sort of runs out. The employers need to take into account specific duty to those with protected characteristics as well. So, for example, employers need to be mindful of their duty to make reasonable adjustments for any employees with disabilities. Expectant mothers will be entitled to suspension on full pay if suitable roles can't be found for them where they can sort of be kept safe. Failure to consider any of these things could result in discrimination claims, so it's just very important for employers to keep this at the forefront of their minds. The guidance also suggests that particular attention should be paid to people who live with clinically extremely vulnerable individuals, even if they themselves aren't or don't suffer from anything. Although the difficulty for employers is it doesn't make clear what that means for employers in practice. It's just something for employers to keep in mind and to consider whether there are sort of policies and procedures that you could put in place to sort of address these situations. So what about staff whose children are off school? As many are. We've got the return to school on a phased basis, but for many that's still going to take some time, and many still don't feel comfortable sending their children back to school. So there is a statutory right to unpaid emergency leave. However, that's only supposed to cover a day or two generally, where sort of a parent needs to find emergency care arrangements for their child. So in practice, in this kind of situation, that's not going to work. So other options may need to be considered. So parents with a year's service or more may have an unused entitlement to unpaid parental leave. Others may be able to use up their holiday or may be able to take unpaid leave. Some employers also might be able to offer adjusted hours or reduced hours, depending on the business needs, etc. Obviously, if you've got reduced hours, generally you would also offer reduced pay. Employers could also, offer to keep those parents that can't return to work on furlough leave. Again, this would all need to be done with their agreement. Taking any action against an employee who may struggle to return to work because of childcare responsibilities may be potentially discriminatory, and any dismissal may be unfair. So again, things to keep in mind. What if an employee refuses to return to work? Well, even where an employer has put in place a safe system of work, where you've done your risk assessment, etc., you've put in those measures, individual employees may still have particular concerns about returning. The key thing here will be communication. An employer may want to consider whether any adjustments could be made to sort of address any of those employees' concerns. So, for example, changing shift patterns to help staff avoid the rush hour if their concern is about the commute, whether they might be redeployed to a role that maybe could work from home or that is sort of less likely to have lots of human contact, or potentially suspension on full pay until appropriate safety measures can be put in place, or alternatively continuing the furlough arrangements. If, for example, an employee is refusing to return to work and you consider dismissal, if you haven't considered these options as an alternative first, any dismissal could be unfair depending on the circumstances. If an employee reasonably believes that there is a serious and imminent danger which they can't reasonably be expected to avert, then they could have a claim for unlawful detriment or automatically unfair dismissal if they are dismissed or disciplined for not returning to work, or if pay is withheld for refusing to attend work. And there's actually some case law which supports the view that the fear of danger could actually even be in relation to the commute to work. So even if you've put internal arrangements in place, if somebody is concerned about their commute, that could actually fall within this category. The extent to which the employer has actually complied with the government guidance and clearly communicated this to the individual will be relevant. However, it won't be determinative of whether a fear of danger is reasonable. The individual's own risk profile will also be relevant. So, for example, if they have any underlying conditions or they live in a household with anyone with underlying conditions, etc., that will all be taken into account in assessing, whether their fear is reasonable. Employers should also bear in mind that employees who complain about the safety of the working environment may also have a protection from detriment and dismissal under the whistleblowing legislation in the UK. And they have alternative options, so they might be able to claim interim relief. I'm not going to go into whistleblowing because, again, it's a huge topic, but it's just something to keep in mind. And let's not forget staff who are continuing to work from home. Obviously, businesses still owe obligations to them, and it's important for employers to put in measures to monitor their well-being and keep in touch with them, because many of you will be working from home, and it's not always straightforward or easy. And well-being is something that's really, really, it's a massive buzzword at the moment, and it's just important that employers stay on top of it. One point I quickly wanted to touch on before moving on to look at redundancies and changing terms and conditions is the issue of workplace testing. So one of the questions we're getting, and it's clear that employers are considering, is what steps they might take to test their staff for coronavirus symptoms. Now, information regarding an employee's health, such as temperature readings, whether the employee is suffering from the symptoms of coronavirus, or whether they've been diagnosed with the virus, that's all special category data under the GDPR. So that's the data protection legislation that applies here. The Information Commissioner's Office has published a helpful set of FAQs for employers on COVID-19 workplace testing. The ICO accepts that employers will often be able to show that they've got a legitimate reason for processing the health data in compliance with the GDPR and also to discharge their health and safety obligations, as long as they're not collecting or sharing irrelevant, inaccurate, or unnecessary data. The ICO notes that the use of temperature checks, which is something that people have asked about, or thermal cameras on site, may not be proportionate if the same results can be achieved through other less privacy intrusive means. And as with all things GDPR and data protection, that's always going to be the key concern. Are there less intrusive ways of gathering evidence and gathering information and using that information? So finally, moving on to redundancies and changing terms and conditions of employment. Unfortunately, as a result of the continuing financial impact of the pandemic, a number of employers are ultimately going to need to consider redundancies or restructuring, particularly once the furlough scheme starts to be wound down. Redundancy is a potentially fair reason for dismissal, but employers must ensure that they put in place appropriate consultation processes to show that you've got a fair process for dismissal, to avoid any unfair dismissal claims and or discrimination claims by employees. Employers may also be considering changing terms and conditions for those staff that it does keep on. For example, seeking to reduce working hours and pay, changing working patterns or work locations, or changing roles and duties. And that might be, as Tim mentioned, in the context of getting people to return to work part-time under the new furlough arrangements from July. But before implementing such changes, the employer will need to consult with any of those affected employees about the proposed changes and seek their agreement to the changes. So where there are 20 or more redundancies proposed in a 90-day period, collective consultation obligations will be engaged. They'll also be engaged if the employer is proposing to introduce changes to terms and conditions for 20 more employees in the same time frame, where the proposal is that if those employees don't agree to those changes expressly, then effectively they're going to be forced through. So the employer would be looking at dismissing and re-engaging the employee on new terms. In those situations, collective consultation obligations will also be engaged. Where they are triggered, the employer will need to inform and consult with employee representatives about ways of avoiding or reducing the number of dismissals and mitigating the consequences. Consultation must start in what's called good time, although there's not specific guidance about what that means, but it must be at least 30 days before the first dismissal, or 45 days if 100 or more redundancies are proposed. The employer must also notify the Department for Business, Energy and Industrial Strategy of the proposed redundancies in a form that's called the HR1 form within the same time period. Employers should bear in mind that due to the logistical difficulties of organising an election, particularly where you've got staff that are furloughed or not actually in the office and in the workplace, the process may well take longer than usual. As such, it would be prudent to start planning for the election of representatives sooner rather than later if there is any consideration that redundancies may be required going forward. It's basically better to start sooner rather than later. The government has now made it clear in its guidance that it is possible to consult with staff whilst they're furloughed. It has also suggested that employers may make staff redundant whilst they're still on furlough. However, that may go to the fairness of the dismissal, because an employer will be under a duty to consider whether the effect of redundancies could be mitigated, and potentially keeping employees on furlough for a period may be a way of mitigating the impact of redundancies. It's also potentially contrary to the spirit of the furlough scheme, which obviously it was hoped that redundancies would be avoided by stimulating employers with this grant. Without meaning to scare you or end on a negative note, I know Tim did with the penalties as well, there are significant financial penalties for non-compliance with the collective consultation obligations of up to 90 days pay uncapped per affected employee. Failure to notify the government can lead to potentially criminal prosecutions against the company and its directors with an unlimited fine on summary conviction. This is why it's so important that we get collective consultation right. And if you think that there is any risk that collective consultation obligations may be triggered, I would definitely suggest that you seek legal advice, because it's really, really important that it's done right. I appreciate that this has been a bit of a whistle-stop tour of some very big issues, but if you have any questions, please do feel free to raise them, or to contact me directly after this webinar if there's anything that you want specific advice in relation to. In the meantime, I'd like to hand over to Vijay Tanna, who will be discussing financing options from the UK government.
Thank you, Anjali. All the legal points well worth considering if you are going down the redundancy routes. Good morning, UK. Good morning, India. Or good afternoon, India, I should say. My name is Vijay Tanna. Bharat have explained the background, and team has extensively covered the various financial assistance provided by the UK government to the UK-based businesses. The UK Chancellor, Rishi Sunak, soon after his budget in March, announced further support to UK businesses in form of loans. The first one I will cover is the bounce back loan, which is meant for small companies who can apply for a loan of between 2,000 and 50,000. The second scheme is CBILS, and the maximum loan is linked to the company turnover of 5 million or £5 million. This was the very first loan announced by the UK government, targeted for businesses with turnover of up to 45 million. The third loan is meant for larger businesses with turnover above 45 million, to 500 million, hence coronavirus large business interruption loan scheme. Finally, COVID corporate finance facility is provided for corporates with turnover in excess of 500 million. Next slide. Bounce back loans. This scheme was launched on 27th of April to provide financial support to businesses across the UK that are losing revenue and seeing their cash flow disrupted as a result of COVID-19 outbreak. Bounce back loans is available through a range of British Business Bank accredited lenders and partners listed on the British Business Bank website. A lender can provide a 6-year term loan from £2,000 up to 25% of the business turnover, the maximum loan being £50,000. Application for loans are made online at one of the accredited bank portal. The scheme gives the lender a full 100% government-backed guarantee against the outstanding balance of the facility. Interest rate is fixed at 2.5% per annum, and first year's interest and arrangement fee is paid for by the UK government. There are no repayments in the first year and no early repayment fee. Next slide, please. To apply, you must first meet the eligibility criteria. You will need to certify that the business suffered loss due to coronavirus, that the business was viable on 31st of December 2019, that it is a UK business with trading or commercial activity. The owners can be resident abroad, of course, or be part of the group, example Indian loan, but has to be a UK registered company. Same for other loans. Not access, and the company should not be able to access any other types of, should not be accessing any other types of loans supported by the government. The company should also derive 50% of the income from trading activity. Next. I'll now touch upon CBIL. CBIL was the very first loan announced by the Chancellor. Since its announcement, it has been significantly expanded along with changes to the scheme's features and eligibility criteria. The changes mean even more smaller businesses across UK impacted by the coronavirus crisis can access the funding they need. Insufficient security is no longer a condition to access the scheme. Slide. No, sorry, go back. Like Bounce Back, CBILS is intended to provide financial support to SMEs with maximum turnover of £45 million that are affected by COVID-19 outbreak. British Business Bank operates CBILS via its accredited lenders, example high streets banks, challenger banks, asset-based lenders, and some specialist small lenders, with the recommendation to use incumbent bank first. The government gives the lender a guarantee for 80% of the value of the loan to encourage more lending, but the borrower remains fully liable for the debt. But if in default, only 20% of the outstanding facility can be recovered under any personal guarantee given. Next slide. To be eligible for CBIL, similar to Bounce Back loan, your business must be UK based in its business activity and borrowing to support this activity, be viable and are not in difficulty pre-COVID-19. Although you no longer need to evidence that, you could trade out of any short-term to medium-term difficulty. Banks may recommend you provide formal forecast if it supports the application. Generally, formal due diligence assignments are not being carried out by the banks, which could be the case for normal loans. The maximum value of the facility provided under the CBILS is £5 million for businesses with up to 45 million turnover. There are 4 types of facilities possible. Term debt and asset finance facilities can be taken over a period of up to 6 years, whilst overdraft and invoice financing facility will be for up to 3 years. Arrangement fee and interest for first 12 months is paid for by the government. Next slide. In terms of security, personal guarantees are not allowed as security for lending of less than £250,000, nor can banks take charge on one's primary residential property under the scheme. However, in case of a default, if the guarantor is unable to pay the 20% of the outstanding facility, The personal assets, including the primary residential property, may come into play as supporting assets. As already mentioned, 80% is guaranteed by the government. Next slide. The Coronavirus Large Business Interruption Loan Scheme, CLBILS, provides finance to mid-size and larger UK businesses with a group turnover of more than 45 million that are suffering disruption to their cash flow due to loss or deferred revenue during this crisis. Effective from 26th of May, the maximum amount available through CLBILS to a borrower and its group has increased from 50 million to 200 million pounds. Term loans and revolving credit facilities over 50 million will be offered by lenders which have secured additional accreditation. The maximum size for invoice finance, asset finance facilities remain at 50 million. Companies borrowing more than 50 million through CLBILS cannot pay any dividend payments other than those that have already been declared, cannot carry out any share buybacks, or pay any cash bonuses or awards any pay rises to senior management, including the board, except, of course, where they were declared before CLBILS loan was taken out, or is in keeping with similar payments made in the preceding 12 months and does not have a material negative impact on the borrower's ability to pay the loan. The government will guarantee 80% of the loan, but will not cover the first year interest or fees charged by the lender. Like with other loans, the application should first be made with your current bankers. In terms of the information required, expect to be asked for the following information: historic accounts to demonstrate viability of the business and demonstrate current and future need for cash. It is good management practice to maintain rolling 13-week cash flow forecasts, especially in times like this. Regular sharing of such information with your bank has its benefits. For CLBILS, it will be necessary to show how long it will take you to repay the loan. For this, you will need to prepare monthly and annual forecasts with detailed assumptions with appropriate stress tests carried out. Next slide. As per UK government's published statistics, total value of facilities approved as at 24th of May 2020 amounts to £27.5 billion in favour of 651,268 applicants. Total applicants made were 854,246. I'm not expecting you to add those numbers up, by the way, just accept them, giving you a success rate of 76.2%. Next slide. Future Fund. One sector of business not covered by any of the funding options mentioned before is the new startups or innovative companies who could not demonstrate historic viability of the business. To support this sector, the UK government has set out a £250 million future fund that will provide match funding using a convertible loans of between 125,000 to 5 million to companies facing financing difficulties due to the virus. The British Business Bank is administering the scheme. To be considered eligible for the fund, UK registered unlisted company incorporate prior to 1st of January 20 must have raised equity of at least £250,000 in aggregate from private third-party investors in previous funding rounds over the last 5 years and have a substantive UK presence. To put this in perspective, as per Beerhurst, if we look at all the UK companies that raised equity funding at this level, only 27% of the companies qualify. The convertible loan will be at most equal to the funding provided by private third parties at exactly the same terms. This means that the funding from the third parties cannot be issued as equity. In other words, that narrows the third-party funders list to institutional investors and the funded companies, an exclusion of angel investors. This is bridge funding for working capital purposes only. Payments cannot be made for dividends, bonus, advisor fees, consultant fees. To demonstrate what is working capital, business will need an up-to-date financial forecast. The government was very clear about the purpose of the loan being a bridging loan with commercial terms. it is very important to note that the third-party investment needs to match the terms and conditions of the government loan. Therefore, it is not eligible for EIS relief. If the convertible loan note is not repaid in full within 3 years, the loan will likely turn into shares or be repaid with a premium. It is believed that the government expectations are to convert the loan into shares rather than be repaid. It seems that the government is taking a VC approach to this loan and hope for some winners. Conversion will be at a 20% discount to the conversion event share price. Quite simply, this means when the loan converts to equity, the government gets a 20% share price discount. This is similar to most convertible loan notes or advanced subscription agreements. The interest rate on the loan is 8% per annum unless investors lend at a higher rate. The interest does not compound and does not convert into equity. The company will have to provide warranties, although there is no mention of a personal guarantee. In closing, worth noting that £250 million won't go far. The future fund is really small, given that as at 27th of May, there had been 419 applications amounting to just over £500 million of fund. The government has indicated that it will increase the fund value. At present, we don't know to how much. Next slide, please. Finally, the COVID corporate financing facility. The Bank of England will buy short-term debt from large companies. It will operate for at least 12 months and for as long as steps are needed to relieve cash flow pressures on firms that make material contribution to the UK economy. That being the key word, material contribution to the UK economy. As a recap, the Bank of England will buy short-term debt from large companies in order to support a company that has been affected by the short-term funding squeeze due to COVID-19. The scheme is delivered through commercial lenders backed by the Bank of England. It will operate for at least 12 months as long as steps are needed to relieve cash flow pressures on firms. That's all from me. Thank you for listening. I'll hand you back to Bharat.
Thanks, Vijay, and thanks, everyone. I think we are very much ahead of our time. You started getting some questions. So guest, in case you have any questions, you could use the Q&A chat section and start thinking about those questions. We are here for another half an hour to address your all questions. Meanwhile, allow me to pick up with few questions which has come, which I will just read it out. If an employee takes a holiday during the furlough period, can the employers apply for the holiday wages as well on top of the furlough salary? Will the employers have to pay the top up to 20% of the holidays? I think, Tim, this is for you.
Okay, so holiday pay was one of the intricacies of the furloughing scheme, and the government were silent on it for quite some time, and that led advisors to give differing opinions on what the treatment should be. We now have the answer from government, even though we may not agree with it. The holiday pay, when an employee takes holiday when they're on their furlough period, they must be paid at their full normal salary, because the working time directive says each employee is entitled to 5.6 weeks paid holiday per year. And if you pay their holiday days, including bank holidays, if they form part of the employee's holiday entitlement, if you pay that at anything other than the full salary, then you're in breach of your working time directive obligation. So first point, holidays are paid at full holiday pay, not any reduced salary that you might have agreed with the employee during the furlough period. The amount you can claim from government as part of the furlough grant is absolutely blind to this point, because the amount that's claimed is set based on the February 2020 salary in most cases, this idea of a reference salary before the lockdown period kicked in. So if the salary in February 2020 was £3,000, the furlough grant is the minimum of £2,500 or 80% of the reference salary. 80% of 3,000 is 2,400, and therefore that is the grant, regardless of what payment is made during the actual furlough period. So the point is, the holiday pay is paid at full pay, and the furlough grant is what it is based on the February 2020 salary.
Okay, thank you. I have a very interesting question coming in, which says, I was looking to acquire a business earlier this year, and one of the banks had given in principle approval term sheet to provide loan of £350,000. I have recently moved to the UK and have no assets. I had opted for EFG route. Now the bank says EFG is suspended for time being, and I'm not eligible for CBILS as the business was not acquired or started before COVID. I should be closing the acquisition transaction by end of October. What are the options for me now?
Vijay, you're on mute.
Hi. Right. No, happy to take that. Thanks, Bharat. I think the person asking the question is referring to Enterprise Funded Loan Guarantee Scheme, EFLGS. That is true at the moment. The banks do tell me that that is currently on hold. It will obviously come back as soon as they get over the crisis, over the CV crisis, because they've got a very huge backlog of applications for CBILS and bounce back loans, etc. My suggestion on this particular point would be if the delegate emails me, I'll be more than happy to discuss various other options available. My email is on slide, vtan@mks.co.uk. The first point of call over here, of course, is to look at the forecast, and we can then explore what other options are available, because this is very much on a one-to-one basis. It's difficult for me to give you a general answer.
Thanks, Vijay. I have a question for London and Partners team. With COVID and Brexit, how would London rank compared to the other cities within Europe to attract FDI?
And to give Hemin Bharucha, our Chief Representative in India, the opportunity to answer that question.
Yeah. Hemin, could you please answer this question?
Yes, thank you very much. Good morning, good afternoon, everybody. I'm Hemin Bharucha. I'm Chief Representative for London Partners in India. I think that's a very good question. We have seen that despite the lockdown, ties between, there are different reports that have come out recently that give stats from last year, which shows that, there are 842 Indian companies who are there in the UK. More than 50%, about 54% of them are headquartered in London. And this number keeps growing. Last year, we at London and Partners, along with our commercial partners, Moore Kingston Smith and Howard Kennedy, helped land a record number of 57 companies in London alone. And this year, while the world has been in lockdown from March, we continue to see 4 companies, large companies, have already set up. And let's not forget that those companies who have set up continue to grow and continue with their investments in London. So definitely a lot of interest from Indian companies, and we continue to talk to them. We see a lot of new sectors that are emerging as well. So post the COVID, traditionally tech used to be a big sector. Interestingly, last year, the fastest growing company in the UK is actually a clean energy company. So new sectors are emerging, new companies are coming out. We have seen unicorns like Oyo and Ola setting up in the UK last year. They are doing very good work in this crisis as well, supporting London. So yes, definitely a lot of interest that we see, and we continue to work with our partners to support these companies.
Thanks, Hemin. Moving ahead, another question is, what is your view on obligations of Tier 1 entrepreneur visa due to COVID? I can also see it's written in bracket, obligations are generating to FTE and invest £200,000. Anjali, will you be able to take that question?
I think Tim actually might be better placed, potentially.
Yeah, well, no, Anjali and I are just exchanging messages on the chat. Look, what we've got is neither Anjali or I are immigration lawyers, so I'm afraid I will talk from general principles. The Tier 1 entrepreneur visa, and we knew and loved the visa category very well. It was very popular with inward investment from India and China in particular. That is a closed visa category now. So if we have a tier 1 entrepreneur in the UK, they've come in before the category closed. The government were very much, or the Home Office were very much of the view that that category of visa was being abused. No doubt was, but certainly there were many genuine business people who've come into the UK and started up, acquired very successful businesses and created employment. I don't think, I was just checking as the question came in, whether there was anything from the Home Office on this. So the Home Office have been pretty poor at making COVID-style announcements in relation to different visa categories, particularly around the Tier 2 ICT visa, which is the one most of our Indian clients use to the greatest extent. I haven't yet seen anything on Tier 1 entrepreneurs. So whether we can expect the government to announce any relaxations or not, I suspect will be on a case-by-case basis. If you feel that you're going to struggle within the visa period to create the 2 full-time positions and invest the 200,000, I would get in touch with the Home Office sooner rather than later. I think it's always best to lead on the front foot and say, look, you're having these difficulties, what extensions are possible. That feels like a better course of action than just keeping your head down and risking a Home Office audit. That said, please do take advice. I think in Howard Kennedy, Angela, you do have immigration colleagues.
We've got colleagues that deal specifically with these matters. We've got immigration experts.
So my speculation of what the answer should be, perhaps the real answer should be, if you drop Anjali an email, she will just run it past her immigration colleague and they can get in touch. But you would hope the Home Office will be sympathetic and there'll be a relaxation, but common sense does not always prevail in government.
Absolutely.
Great. Thanks, Tim, and thanks, Anjali. I can see another question being popped up. Currently, there is no bilateral agreement between UK and India. Is FDI in India is safe?
Well, the Bank of England does not extend its powers on the funds invested in India. I think it's fair to say it's difficult to comment on that particular question. If Mr. Jadeja provides some additional information, I might be able to assist further.
Okay. Thanks. Anjali, I have a question for you. At what point are the collective consultation obligations triggered?
Yeah, so as I mentioned, they're triggered where the employer is proposing to dismiss as redundant 20 or more employees at one establishment in a period of 90 days or less. But the problem is there's no clear definition of what proposing to means. The case law suggests that it will be something less than a decision, so you don't necessarily have decided you're making redundancies, but something more than a mere contemplation. You could have the obligation arising where you're considering alternative options, but you've got sufficiently far into the process that actually redundancies is potentially a real option. To avoid inadvertently triggering those obligations, what I would suggest is that employers should be quite careful about what they put in writing. You don't want too much of a paper trail setting out, or this is, between management, you'll quite often get, well, we'll probably end up having to do redundancies, when actually you haven't really got to that point. One of the other ways of trying to protect yourself is getting lawyers involved, whereby you have some protection with privilege. So your communications between you and your lawyers about what your potential business contingency plans are then protected. Because if you don't go down that route, the difficulty is if anyone was to challenge it and to bring proceedings, then that information, internal information in particular, would be disclosable in the court proceedings and would be potentially very unhelpful given the penalties that I've set out for you already.
Right, thank you. Hemin, I have a question for you. In our day-to-day, working in these COVID times, we keep on receiving a lot of queries from people, and they ask, like, in this current situation, how can companies understand and assess UK or London as a region to set up, especially when travel is not possible, they cannot, go go to the market? How do they, tackle this kind of a situation?
Thanks, Bharat, for that question. I think, like everything else, we are always there to talk to our companies. Today, Zoom seems to be the medium for everybody to communicate without even traveling. So in a way, that's good. But we are always there along with our partners like Moore Kingston Smith and Howard Kennedy to advise companies like we are doing. We've been hosting a lot of sessions, webinars with our partners to give a lot of advice to companies, which is always useful. There are a lot of other events that have moved now to a virtual platform. So for example, COGEX, which is a big event that happens each year, a physical event. We at London and Partners, we are partnering with COGEX and we are offering passes to companies who would like to attend this year's, and it's virtual, so you don't have to travel. None of those restrictions are really there. Those passes cost a couple of £100, and we at London and Partners would be happy to offer it to companies who are on this call. So there are various ways that we are working with companies. A lot of it right now is obviously virtual, but that support continues to be there from London and Partners. So please do get in touch with us if you would like to attend COGEX. We also have the London Tech Week, which will be coming up on the 8th of June pretty soon, and then a much larger London Tech Week, which has been postponed to September, where again, London and Partners will be actively involved. So very happy to talk to you about any of these events or any support that you're looking for.
Thanks, Hemen. That's a very good answer with respect to the upcoming events, and perhaps that could bring some great opportunity for people to travel in the future times. Tim, I have a question for you. My employees are on tier 2 ICT visas and have restricted access to public funds. Can they access the furlough scheme?
Yeah, it's a question we got a lot in the early days of the furlough scheme, because restricted access to public funds does mean that employees on secondment from India to the UK can't access much of the government support for people who are UK nationals. However, the furlough scheme had no such restrictions, so the furlough grants are not public funds for this purpose. So there is no exclusion, no barrier whatsoever to non-UK nationals accessing the scheme, or at least their employers accessing the scheme on their behalf.
Right. Perhaps we can take one more question, unless someone wants to quickly chat that. Anjali, this is for you. What should an employer do if an employer notifies them that they have been advised to self-isolate as part of the government's test and trace program?
Those people that have been identified under that trace program, they basically shouldn't be attending the workplace, and you shouldn't be allowing them to. So the question is one, can they do the work from home whilst they're self-isolating? If they can, then that's the first option, of course. If they can't work from home, then they will be eligible for statutory sick pay. So even though they are not sick, they will still be eligible, and that's the route that the employer should go down.
Great. Thanks for that answer. I think we'll wrap up our session for this time. So thank you, audience, for all your queries. In case you have any other queries, then please send it to my email ID mentioned on the screen, or to the respective speakers from London and Partners or Howard Kennedy. Finally, I would like to thank all panelists, especially our guests from London and Partners and Howard Kennedy, who have spared their valuable time to come and update all our viewers on this latest topic. Moore Kingston Smith will come back with more such innovative and latest updates through webinar in coming weeks. Till then, stay connected and stay safe. Thank you very much.
Thank you.
Thank you.
Thanks very much.